One, I'm William Johnson, Chair of the Baltimore County Blue Ribbon Commission on Ethics and Accountability. We apologize for a slight delay in starting. Had a little bit of technical difficulties, but we're here now and we're ready to go. It is my pleasure to welcome my fellow commissioners and members of the public who are viewing the session to this meeting of the Baltimore County Blue Ribbon Commission on Ethics and Accountability. During this meeting, we will hear any comments that members of the public would like to make about ethics and accountability in Baltimore County. And we will also hear what our commission members have learned from our fact-finding work over the past 5 months. Before we begin, I would like to clarify something from our last meeting. Subcommittees were established for this commission to do supplemental information gathering, especially for individuals who wanted to speak confidentially and in their personal capacity without fear of retribution from any other parties in Baltimore County. I want to apologize for any confusion that there may have been on this issue. Would also like to remind everyone about our housekeeping items. As we have shared before, this session is being recorded. The agenda for tonight's meeting was shared with members of the commission directly and is posted on the commission's website, that website being www.blueribbonethics.ubalt.edu. The meeting is scheduled to conclude at 8:30. If we cover the agenda items before then, the meeting will close early. I might add that if it looks like we're going to run over 8:30, we will at that time as a commission decide whether or not we want to continue or whether we want to table things and pick it up in a subsequent meeting. All agendas, minutes, meeting links, and commission materials will be posted on the commission's website. We will not be responding to comments or questions posted in the chat. Questions or comments can be shared with the commission by email at blueribbonethics@ubalt.edu. Commission members will have, of course, the opportunity to ask questions or comment during the meeting and can do so by raising your hand or using the raise hand function in Zoom. And so we'll move to a review of minutes of the previous meeting. Those minutes were provided to commission members by email earlier this week. So do any commission members have any comments or changes to the drafted minutes? No? Okay. If there are no further corrections, can I have a motion to approve the minutes?
So moved.
And a second?
Second.
Okay, thank you. The minutes are approved as distributed, so thank you. And so at this time, we're going to move into our public comment period. And tonight we will start with that time for public members of our audience to make comments about the topics under the commission's purview. I would like to remind commission members and the audience that county employees and the public have had a number of ways to provide feedback for the commission during our work. Since we began, Baltimore County employees and members of the public have been able to provide comments via email to blueribbonethics@ubalt.edu or on the commission's website. Individuals who made comments through the website did not have to provide contact information, and most did not. Any comments made via email or the website have been forwarded to each of the commission members, and individuals who requested a meeting about their comments were scheduled to meet with one of the two subcommittees. During the summer, all Baltimore County employees, elected officials, and members of boards and commissions were asked to participate in the ethical climate survey conducted by the Schaefer Center. 1,740 individuals chose to do so. The results of that survey have been provided to commission members and the public at previous meetings of the commission. Members of the commission also received a draft of the report's findings. This report will be included as part of the commission's final report to the county. Near the end of the survey, respondents were provided with an opportunity to indicate if they would be interested and willing to speak with the commission about their experiences with suspected ethical misconduct in Baltimore County. Respondents who indicated they would be willing to do so were at the end of the survey redirected to a separate survey to record their contact information, since the ethical climate survey responses were anonymous. After a series of follow-up communications, individuals who provided email addresses were invited to virtual meetings with one of the two subcommittees of the commission. We appreciate the comments that have been made through these channels and the individuals that took time to speak with the subcommittees. Your comments will inform our discussion later tonight. Further, I want to note that the commission's recommendations are non-binding. While no recommendations have yet been developed, we anticipate that some may need to have legislation developed, and that during that process, the county council or other parts of the Baltimore County government will provide public comment periods. So we will proceed tonight with public comments as follows. Individuals will have 3 minutes to speak. At the end of that time, we will ask them to stop. Commission members are welcome to ask clarifying questions, but we otherwise will not be asking follow-up questions. We will also not be responding to any questions made during the public comment periods. Individuals who registered in advance to make public comments will be called on in order of signing up. And so you see those names. This is the order in which we'll proceed based on what you see on the screen. The individual's microphone will be unmuted by the university's Office of Technology Services representative and then muted when the 3 minutes have passed. Anyone who did not register in advance but who is here tonight and would like to make public comments should use the chat function on Zoom and message Sarah Finesis directly that they wish to comment. Their names will be added to the list, and they will also be provided 3 minutes to comment. Again, commission members will not be responding to public comments tonight. This is an opportunity for members of the public to make your views known in this setting. And so at this time, we're going to ask Sarah if she would call on those individuals who have signed up.
Thank you, Chair Johnson. The first individual who signed up is Andy Gross. Mr. Gross, I've asked you to unmute your microphone so you can start speaking. I can unmute your camera if you request.
Sure. Good evening. Can you hear me?
Yes, we can. Good evening. Thank you.
Oh, great. Thanks. 2.5 years with the pandemic and still not sure how to use Zoom. So good evening. Thank you for taking my testimony tonight. My name is Andy Gross. I am an attorney in Baltimore County. I am also a veteran, active duty Army for a number of years. And I think germane to my experience was that I was an ethics counselor for the Department of the Army for a number of years. So government ethics are something that that are very high on my priority list. And the reason for that is because in our society, institutions are important. They bind us together. They enable functioning society. And the way those work is through trust. And trust in institutions is absolutely paramount in order to really have functioning society. And I think that distrust right now is at an all-time high. So the way to restore that trust is to err on the side of transparency and err on the side of ethics. So I can't get into the weeds as to the specific issues on the table, but I ask that the commission, when reviewing the various proposals and the law as is, consider erring on the side of a strong IG with adequate funding, its own independent legal counsel, as well as adequate resources to ensure transparency in Baltimore County government. Because this transparency is what ultimately engenders trust. I know there's always concern about oversight of an inspector general. The question always is, who watches the watchers, right? But I think in that case, we should be looking to the peer groups, not the peer groups, but rather the organizations of inspectors general to look to them for best practices. Because of course, we do need somebody watching the watchers, but at the same time, I think that overall, we really need to err on the side of enabling a strong inspector general with access across the Baltimore County enterprise, meaning broad access to IT systems, broad access to files, broad access to personnel. Obviously, those personnel should have their rights protected. But ultimately, the goal here is to rebuild and engender trust going forward in our institutions. With that said, I yield the 18 seconds I have left.
Thank you, Mr. Gross, and thank you for your concern and your interest. Okay, Sarah, we'll take the next individual.
Our next speaker is Rose Kinder. Ms. Kinder, I've unmuted you. Please let me know if you want your camera turned on. Otherwise, you are free to start speaking.
Okay, thank you very much. Good evening, members of the Baltimore County Blue Ribbon Commission. My name is Rose Kinder, and I am a resident of Baltimore County. And I am a very strong supporter of our Baltimore County Inspector General, Kelly Madigan, and the work that's been performed by her office since it was established by our county executive and the county council. I urge you to further strengthen the independence and scope of the Office of the Inspector General with the following recommendations. The county charter should be amended to include the Office of the Inspector General so that it cannot be removed by legislation. The Inspector General should be provided with funding for independent legal counsel, either on staff or outside legal counsel. Number 3, no advisory or oversight committee should be formed. Number 4, the Inspector General should provide whistleblower protections for those people who come forward to provide information about waste, fraud, and abuse in our county government. Number 5, the Inspector General should not have to disclose pending or current investigations to county or agency leadership. Number 6, remove the Ethics Commission from the Office of the Inspector General. 7, funding for the Office of the Inspector General should be a recommended percentage of the entire operating budget for Baltimore County. Our county executive should seek to reach this target funding. 8, increase the scope of the Inspector General to include audits, thus increase the funding and centralize these functions. And 9, increase the scope of the Inspector General office to include our public school system with a commensurate increase in funding due to the size of the Baltimore County public school system budget. We have a terrible lack of insight into our Baltimore County public school system operations and their fraud, waste, and abuse. And let's incorporate their audit functions into the Office of the Inspector General. And I thank you for your time and attention and your good work to date. Thank you.
Thank you, Ms. Kinder. And again, thank you for your concern and for the information you've shared.
The next speaker is David Plymire. Mr. Plymire,
Good evening. Yeah, thank you. Good evening, Mr. Chairman, members of the commission. Do I have my microphone on?
Yes, you do.
It's good for me, probably not to, you know. I have two basic observations. Well, actually, I make a third. The comments by Mr. Gross and Ms. Kinder, I fully support, particularly as to the need to strengthen the Office of Inspector General. as well as to preserve its independence. I guess rather than repeat things they would say, I want to make two points that I think the commission should keep in mind. The first is the Office of Inspector General is not broken and doesn't need fixing. I think you may have heard from some people aggrieved by the commission's actions and investigations. Well, that's part of what happens when people are under scrutiny and investigations are done by their conduct. I think you've also probably heard from the community in general, which is very, very much invested in having a strong and independent Inspector General. The second fundamental point that I would make is that there is one thing that's broken, and call it the ethical climate, institutional culture, or whatever you want to call it within Baltimore County government, and that is broken. With all due respect to your ethical climate survey, and I'm a believer in collecting data, I'm not sure what better metric you could have on the ethical climate within county government than the rather remarkable, maybe in some other context, some other counties and cities that I've had the opportunity to work with, the remarkable flow of information coming from reports by the IG and by the news media on the ethical climate in the county. It's broken. The IG is part of the fix. I would hope that this commission sees its role as helping the IG be part of the solution and continue to be part of the solution. The good news from within county government, and there's an element of bad news, is that there are more shoes that are going to drop. As some of you know, I write things that are published in newspapers. You may have seen one this morning in the Sun. What happens is I get phone calls. There are more shoes that are going to drop. And part of that is because they have confidence in the IG and the processes of government now that there's somebody listening. So I wish you all the luck in the world, but please do right by the residents of Baltimore County. Thank you.
Thank you, Mr. Plummeyer. And again, thank you for your interest and for your concern. Thank you so much.
Take care. Good night.
Okay.
The next speaker is Beth Miller. Ms. Miller, you should be unmuted.
Okay, can you hear me?
Yes, we can.
Okay, thank you. Good evening to the commission, and I want to thank you for this opportunity to express my robust support for the Office of the Inspector General in Baltimore County. I concur with the points made by the previous three speakers. To tell you who I am, I'm involved in several advocacy groups as a member of my community association board, a delegate to an umbrella group of community associations in Towson, and an executive committee member of a environmental group. And I'm speaking tonight representing myself as a taxpaying citizen of Baltimore County, but it is through these organizations that I've learned the critical importance of oversight of government activities. In each of these positions, I have occasion to advocate for various quality of life matters that impact my community. And in these positions, my eyes have been opened to examples of taxpayer needs subverted to those who are more powerful or well-connected. The Office of the Inspector General, as you know, was created to provide increased accountability and oversight in the operations of Baltimore County, and it is sorely needed. You only need to look through the annual reports to this office to see the high professional standards of this office, the number of complaints to and the number of investigations by the IG are steadily increasing as I think a reflection of people's faith in this office. And the reports are revealing some uncomfortable truths about how business as usual is conducted in Baltimore County. For those of us who volunteer our time to improve our community, it's very important to know that there is an office independent and with guaranteed sufficient funding from the county executive, and county council that can receive and investigate complaints. As Mr. Plymire said, it's inevitable that feathers will be ruffled in those bodies that are being investigated by this office, but that is all the more reason for it to remain fully funded and independent. The reality is that a watchdog keeps people and institutions honest. Our government needs to know that they are being held to an ethical and legal standard of following the laws and policies of this county. Thank you very much.
Thank you, Ms. Miller, and thank you for your interest and for sharing your interest with us as well. Thank you.
The final person who is registered to speak is Dave McClintock. Mr. McClintock, you should be unmuted.
Thank you. In the event that anybody has a hard time hearing me and the signal's bad, please let me know and I'll try to call in. So my name is Dave McClintock. I was the former Inspector General for Baltimore City, and I've been a former Inspector General for Jefferson Parish, Louisiana. All in all, I've been in this role for 12 years. I've learned a little bit along the way. And I think that what I wanted to convey is just that any time that an Inspector General is inserted into municipal government, it's a sea change in how things are done. No other position has the authority and the responsibility and the duty of properly funded and independent Inspector General. And quite honestly, oversight can be uncomfortable. It's uncomfortable for all parties, but it's necessary. And I think what we hear from the citizens calling in tonight is a demand for it. The things that I think I've learned are most important over a decade plus of doing this is that Inspector General has to have independent legal counsel. They have to have access to data, very broad access, and they need to be able to see virtually every type of confidential and privileged information. Along with that comes a duty to protect it in the same fashion as the people that held it before. For a very long time, I've had access to attorney-client information through that same mechanism. It's a very high responsibility for the Inspector General to maintain that data and use it effectively and lawfully. But it can be done and it must be done. You need to guard against barriers and shields to information that those are impediments to true oversight. I think good, clear subpoena authority where they have the opportunity to go to the courts and seek compelled testimony and compelled evidence is fantastic. It's necessary. Secured funding is also necessary. I know many of those things are being talked about and discussed through this Blue Ribbon panel. I will also say that it's oftentimes a journey. When I was the Inspector General in Baltimore City, I was working under an executive order. Indeed, the reason I chose to take a non-Inspector General's role is because I learned the weakness of that executive order methodology. The city has since fixed that and remedied that. And I think that's a demonstration of the journey that often goes on with Inspectors General offices. This Blue Ribbon Commission has an opportunity to play a role in the responsible development of an Inspector General. And I'm excited about that. All of the issues that I see on your agenda are issues that I have heard brought up off and on over my decade plus of doing this. They can all be solved, they can all be remedied, and they can all be done so in a manner that leaves the Inspector General in a very advantageous position to perform the duty that she's required to perform, which is independent oversight of all elements of county government. So I wish you all the best of luck moving forward on this, and please keep in mind she needs the authority to be effective.
Thank you, Mr. McClintock, and thank you for sharing your interests, and thank you as well for your service. And so was that the last person, Sarah?
Yes, nobody else has signed up to speak tonight.
Okay, all right. So let me just take this moment to thank all of the citizens who have taken your time to speak and to share your concerns and your interests. And please know that you have been heard by this commission. And as we deliberate, that what you have shared will be taken into consideration. So again, we thank you for taking the time to share your comments with us tonight, as well as for those who have written comments. As we said before, we've received those and we have shared those with all of the commission members. And so again, we're appreciative. Each of us are also citizens of Baltimore County, and we care. about government in Baltimore County as well. And that's why we're volunteering to do this work. And so we're going to move into our commission discussion segment. Throughout this process, the work of this commission has been guided by an initial series of questions that were developed. During the course of our public meetings, we heard from the Baltimore County Inspector General, the Inspectors General from Baltimore City and Montgomery County, experts in the field, and about the findings of the best practices research and the ethical climate survey conducted by the Schaefer Center. And the subcommittees have conducted their fact-finding research on issues under their purview. As we've done all this, the list of issues has grown and, of course, been refined. And so, as you can see, the agenda outlined 15 issues for our discussion tonight. However, I'd like to note that in some cases, there are multiple subordinate issues under the larger topic. And so members of the commission will also be able to raise any other issues they believe should be discussed as we proceed through this list. We will discuss each issue on the list based on what subcommittees heard during their fact-finding and what we also learned in our public meetings, including information that was shared by the public tonight and via writing. The goal is to develop a preliminary recommendation or thoughts on how the county should address the issue. Staff from the Schaefer Center will be taking notes. We're attempting to get through this list tonight, so I encourage commission members to keep our discussion of each issue, if possible, to 5 minutes. We know that in some cases that might not be possible. Our concern really is producing the very best product that we can that will be helpful, again, to county government, as well as helpful to the Office of Inspector General. And so we do want to make sure that we give it due diligence. And so I'm not going to try to rush us through it, but we want to get through as much of this as we can. And so I'm going to start by calling the list of issues in order. And we will ask subcommittees that gathered information on these topics to share information you have gathered, and then we will open it for discussion. So we're going to start with the first one, which is responsibility for investigations only or investigations and audits. And that fell under the organizational structure and accountability subcommittee.
Good evening, Mr. Chair, Commissioners. We've divided our topics up as a subcommittee. I will go first. Responsibility of investigations only or investigations and audits. Briefly, we felt that we heard some pretty solid, had some pretty solid communication with people bringing information on this topic, that it was working as it was or as it is, that the, although we did hear that a best practice is that the audit function be combined with an IG. We did see or feel that it's been working with the divided investigations only and the audit under its own function. So that was pretty straightforward with that one.
Okay. And so it sounds then that the recommendation at this stage may be to keep them separate, or what's the thinking on that? And we're open to discussion from others to keep
Okay,
them.
I would like to hear further discussion if anyone else from the other subcommittee had a question or.
I would say that our subcommittee also received some information on this topic. We talked to the county auditor. We heard from others that touched on this issue. And while I thought the information we got from Montgomery County, which has a combined function, I mean, that was an impressive presentation. It totally changed the sort of feel for the function of that office. Our subcommittee felt that frankly, it was working well as it was, that the exchange of information from the county auditor to the IG and back in appropriate circumstances was working. And there didn't seem to be any compelling reason to change any of that at this time.
Any other discussion or thoughts on that?
Okay, so that's all we have on that topic.
Okay, Okay. And so as we're moving through these, we're going to try to just again begin formulating recommendations. These will not, of course, be finalized tonight, but if we can just have some idea of where we may be going with the recommendation, we can do so. And so again, I just want to make sure that I'm hearing it correctly, that one possible recommendation under this topic is to keep those two functions separate for Baltimore County. And
Correct, that's correct.
okay. 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 If there's nothing, I'm sorry. Go ahead. Yeah, John.
No, I was
Oh.
gonna,
Oh, I'm sorry. It's Jenny. Go ahead, Jenny.
yes, if I may move on. So the next, number 2 is staffing the Office of the Inspector General.
Mhm.
And interested in hearing additional information on this from the other subcommittee. But in all, there may be a need for additional funding. It would depend on what the funding would be used for, as we've seen that additional funding has been provided to the office. So going forward, what did that look like? And certainly from testimony, we've heard that the office did need additional staffing and additional funding for that staffing. So another topic later on will also impact how the staffing of the office looks. So it's not an independent topic that stands alone. So we'll probably be able to combine this with another topic, but as it stands, it needs further consideration.
Okay. Does anyone else want to weigh in on that subject, staffing, based on what you have read or what you've heard? No. Okay. So what's the other area that you feel may that may impinge upon, so that we have an idea?
The ethics, where ethics falls within the OIG or not.
Okay.
Specifically, maybe the independent counsel discussion, and then financial independence also may weigh on that.
Okay.
Mhm.
Okay. So we can circle back to that as well. Okay, good. And well, the next one is independent legal counsel.
Okay, John?
Yeah, thanks. Can you all hear me?
Yes.
Good evening, everyone. Well, I think in our group, and based upon what we've heard in our own discussions, there's broad agreement that the office ought to have independent legal counsel. That is a difference, unlike the prior perhaps ratifications and other ratifications. This is a recommendation or a consideration of a change. Obviously, there are lawyers in the office, but they're not serving as counsel to the office, as Ms. Madigan pointed out to us when she met with us. And again, for context, to remind everybody, and for anybody else who might be listening in, the office is represented by the county law department now as basically a unit of the county government, and that creates potential conflicts. It creates conflicts for Ms. Madigan or for the IG, whoever he or she may be, when trying to get legal advice on matters, particularly when the matters involve other members of county government who might be the subject of or the focus of or other inquiries by the IG. And then it also creates conflicts for the county law department itself, of course, which has to is in the position of having to represent multiple interests within the county government, as opposed to the county's collective interest versus outside or third parties. So it's not just for the OIG, him or herself, it's also for the county in general and for the law department in particular. We discussed a few ways about how we might resolve that, and here we would want some discussion and some further input from the larger group. But of course, one option would be to have a lawyer on the OIG staff, sort of counsel to the OIG or the general counsel, whatever you might call it. The sort of drawback on that, of course, is that it's not clear. In fact, it's probably unlikely that the office has the need of independent legal counsel, 7 days a week or 24/7 or whatever you might say. It's more a question of when it's needed, it causes a problem, and it is needed from time to time, predictably, but not all the time. So I think there's a sense, particularly as we're talking about costs and other things, that the budget might be more efficiently used in other ways. It is not atypical to have access to outside counsel. That would be a outside law firm that is procured through a county procurement process on some sort of retainer or whatever the fee arrangement might be. Of course, that's a third-party cost to the county, but a cost that is borne not atypically again in these sorts of situations, and would hopefully be borne only as necessary when it's necessary to have that sort of outside independent counsel. Of course, it's sort of drilling down through these decisions. Then the question becomes, who decides when you get to use that independent counsel? And here, I don't think there's any clear answer to the question. One might say that it's the county attorney. Well, one might start by saying it's the OIG. That would be the most intuitive one, where the IG would say, I really think I need independent counsel here. But we don't really see this as a situation where the attorney, where the IG and the county attorney are at odds. Presumably, the county attorney is thinking like a lawyer and would say, you're right, this is a conflict, and it does make sense for you to get separate representation. So you could make the argument that the county attorney could make that decision. I cannot represent you in this matter, and therefore we should go out and use the contract, the procurement that we've undertaken. You might make it a joint decision. And I don't think we really settled on a particular outcome. I think we decided we would want to have some discussion here about it. But the threshold issue, which I think this group did feel very strongly about, is there ought to be access to truly independent counsel. It ought to be done in a cost-effective way, but we have to manage the kind of logistics and issues that I just described. So that would be where we are on independent legal counsel. I invite, of course, the committee members as well as other discussion on the subject. Thank you.
Okay. With regard to that area, John, was there any discussion regarding budget? So would it potentially be that a part of the OIG's budget would include budget for independent counsel, or?
I think from my perspective, and I think I speak for the group, it doesn't really matter. I mean, because there needs to be provision made for it, maybe some allowance in the budget. We don't really, there might be a year in which it's never spent. There might be a year in which more is needed. The county deals with those kinds of things all the time. This wouldn't be that different. And that could be paid from anybody's budget, including the law department itself, because the fact that the law department might be paying for it doesn't change the fact that the attorney-client relationship would be with the OIG. This is not to impose additional obligations on the county law department's budget. This is intended to be an additional amount that is appropriate for, this potential use. So this is not to take it out of anybody's budget. It is supplemental, and the question of which budget it is may not really matter very much.
Okay. Okay. The discussion.
I would say that this topic, while not within our purview, certainly came up, a little in discussions before us. And at least my reaction was consistent with what John has just suggested, that there is a need for independent counsel. There is a conflict with for the county attorney to be attempting to do it. It makes sense. I mean, the county uses outside counsel for various things as it currently stands. There's a process in place to, contract with. So I think to me, it's a question of adding money to whether it's the county attorney's budget or the OIG budget, matters not. But to estimate a cost for that on an annual basis and have it reviewed. And we didn't get into the current protocols for how a decision is made on whether or not the county employs outside counsel for independent matters. But it would seem to me that should inform the process here. And that intuitively to me, it would be a joint discussion. But there certainly is a need for the IG when they deem it appropriate to have outside and independent counsel.
Okay. Does anyone else want to weigh in? No. So it sounds then like that we may have a recommendation for independent counsel. We just need to kind of determine what that will look like and how that decision will be made. And so perhaps some further work needs to be done in that area in terms of making that determination so that it's a good solid recommendation. Perhaps even based on what's the current practices in the county. Does that sound about right? John and Janine and others who have looked into this issue?
Yes.
Okay, thank you.
Tom, you're up.
So we're looking at financial independence.
Tom, that's yours. I think he's muted.
Okay, am I unmuted now?
Yes,
Yes,
you
you
are.
are.
Okay, yes, financial independence is critical for the proper functioning of an OIG because they're always living in fear if they step on the wrong toes, they could have their funding cut. And so best practice as established by the model legislation, the Green Book, and Professor Klemp's book is that you consider tying the budget to a fixed percentage of the general fund. So you couldn't have the budget cut because someone doesn't like the results or recommendations coming from an investigation. We were looking at this in an atmosphere in which the budget has been increased. The question, I think the question that we did not come to a clear consensus on is whether or not it should be tied to a fixed percentage of the general fund. That's what, in theory, that's what best practices is. In practice, it's very rare for that to be done. And I think maybe a majority of our group thought that might be a step too far because it's not really essential to do it. And it's kind of a radical action in terms of tying the county council's hand. One member of our group kind of came out on the other side that we should tie it to a percentage of the general fund. And I would point out that right now in the statute, they kind of take a middle ground. They don't tie it to the general fund. They certainly can decrease funding. But in the statute, it says that if they do decrease funding in absolute terms, they have to justify that. And so that's kind of maybe splitting the baby between tying it to the general fund and saying that they can just decide on the budget each year. One possibility to take it a little bit further, if you don't want to go as far as tying it to the general fund and saying that the county council cannot decrease funding as a percentage of the general fund, is just to use the language in the statute and replace the term, cut the funding in absolute terms with as a percentage of the general fund. In other words, require the county council to justify it if they do want to reduce the funding as a percentage of the general fund. But I won't say that we've reached a consensus on that issue, and I think it's something that deserves fuller discussion from the rest of the committee.
Okay. So, and the work that you guys did in terms of information gathering when it comes to funding and looking at the statute, and I did note that as well, Tom, that it says it can be decreased, but it has to be justified, and it wasn't clear to me just in reading who is it justified to, and then who makes that final decision as to whether or not the justification is reasonable.
Yeah, I think the statute is silent on that. So I'm not sure if it's trying to give the existing statute a legal right to the OIG, if it's not justified, or just to kind of require the county council to go on record, and then they can do it if they decide to do it. But if you require them to go on record as doing it, then the public can have some input and say they're not comfortable with that, and the county council will proceed or step back.
Mm-hmm. Okay. So again, I'd like to open up to further discussion. Anyone else want have an input?
And I guess in the last point, the theory behind tying it to the fixed percentage of public funding is that presumably as the budget increases and the number of people in the county increase and the size of the government increases, the need for investigations will increase in a corresponding way.
Mhm. Okay.
Mr. Chair, I'll just say, as one of the three of us who was not in favor, or at least was uncomfortable with the idea of tying it in some way, I just don't know what that number would be. And while the Inspector General is absolutely essential to the functioning of government and deserving, I just don't know if you don't do that for other stuff. It just seems to me, I don't know why you do it for this, and it just seems like a slippery slope, because everybody has their view about what's the most important thing in county government. And I think that would be a really bad way to run a government, which is to start saying these things are so important that they get this fixed percentage. I realize that there is some risk in that. Certainly, there is some mathematical risk, and we could potentially strengthen the language that's in the code now about what a written justification is. I think I hope that ultimately we're going to have some sort of process that looks at this whole structure on a periodic basis. And it just seems to me that that is a sufficient, arguably a sufficient check on the process and on budgetary abuse by a future county executive or future county council, and maybe even on the then existing one, if there is a public requirement for this justification. It's not a perfect solution. I just personally am not comfortable with the idea that we should start taking things in the budget and saying that this thing has to be X% and never any less. So I'm looking for another way to achieve the funding stability and to avoid any sort of punitive behavior, which you certainly want to avoid, without doing the sort of absolute percentage concept.
So let me ask you this, is the nature of an Office of Inspector General, and this is general and just not just Baltimore County, but the nature of an Office of Inspector General so different from other functions of government that it may be more susceptible to being attacked through its budget, that it warrants a different kind of look? Is that?
Yeah, historically, there's support for that because some of the witnesses we spoke with from the other IG's office, it has happened in Inspector General's offices where they've been wiped out, just done away with, and a couple of times reinstated. And in other cases, they've had their funding cut. And it is kind of a unique office in that, it's investigating people who have control over its budget. Other areas of the county government aren't doing that to the degree and extent that an OIG does. So an OIG is in a unique position. And if you wanted to tie it to what John had mentioned, what percentage do you tie it to? One thought I had is you take the existing budget, figure out what percentage of the general fund that is, and then just tie it to that going forward. And that would be a floor, not necessarily a ceiling if the need arises for increasing it.
Mm-hmm.
And I guess the last point I'll make is, it is, if you look at the resources, it is best practice, but you have to balance that against the fact that even though it is best practice, very few jurisdictions do it, and that may be because of some of the practical concerns that John has raised.
Mm-hmm. Yeah, Kathy?
I again generally concur with what John had to say on this. I mean, and I understand the reasons that you want to make the office secure from sort of retaliatory practices where they're controlled through their budget. But I mean, we're looking at an office right now that is in a growth. I have no idea how you would benchmark what that number should be. I think one of the things that became very clear was The office is growing, it's growing rapidly, it's doing the things that you would want it to do, and we want to encourage an atmosphere where it continues to increase in size and scope. And the county has responded appropriately in budget increases in the last 2 years. I have trouble in my head figuring out how we would come to a recommendation where we benchmark it on something and that's appropriate for now, but accounts for the growth that I think that the office anticipates it's going to continue to see. So I think there could be language that strengthens the requirement that it be, funded at an appropriate level for the size and scope of the operation that it has. But I understand why benchmarking it to some number is appealing. I don't see as a practical matter, particularly at this stage in the growth of the office, that's doable.
Okay. And to the extent that a lot of this discussion is around making sure that, it can't be have its budget wiped out or the office, be wiped out simply by using its budget. And one of the things that we heard in testimony tonight, one of the recommendations, and I'm not sure how that would work, but is to have it put in the county charter to make sure that it's not easily wiped out. And that doesn't mean that, the budget can't be affected, but that would keep the office perhaps. And again, I don't know that for fact, but perhaps keep the office from, easily being wiped out. Is that something that we should look at in conjunction with the financial independence?
Well, that does, yeah, that would provide. I mean, we had not discussed this in our subcommittee, but I think it's a valid point that does provide additional protection where you cannot eliminate the office by statute or ordinance if it's in the state constitution. But we had not specifically discussed that as a solution as a subcommittee.
Mm-hmm.
But I mean, that's why it's good to have input from the public tonight.
Mm-hmm. Okay.
It's also something, I don't know whether they're similar. We didn't get to this level of sort of the granular level of this, but I don't know whether the budget office has other things that have some sort of special recognition or protection in the county budgeting process. It might be helpful if we're going down this road to talk to someone in the budget office and see what's the most appropriate way of securing sort of protection for this function within the county budgeting process.
It's a good suggestion.
Okay, so then we need to do some further work on this, but it sounds like we're kind of leaning to the recommendation of ensuring some form of financial independence. It's just a matter of determining what that should look like, what makes sense in this context, in Baltimore County's context. Is that correct? We agree with that? Okay.
Yes, and whether tying it to a fixed percentage of the general fund is a bridge too far for some people, as I think it is.
Okay. Okay, good. Any further discussion on financial independence? If not, then we'll move on to unrestricted access to materials and policy process and procedure subcommittee.
I should have followed Janine's model and assigned out my topics. It's a good idea. If I could, I'd like to do this one and the one that follows, which is the subpoena waiting period, which frankly, we heard no comment on in any of the information we got, but the two kind of are related. It was the clear feel from our group after hearing to discussion about access to records and how that has developed, that there should be unrestricted access to records so that the OIG can independently access. It is important to promote the independence of the office and not only promote it and support it, but also make it clear that they have unrestricted access and are charged with looking into things in a manner that they think is professionally responsible. So we would support the concept of unrestricted access. While we didn't hear really anything about the subpoena waiting period, I remember from early commission discussion, there was this policy of waiting 90 days, which seems unduly long. I don't think the reaction to that has changed. If records aren't produced in a timely period, that there should be, they should have the right to subpoena and act promptly. Whether that period is 30 days would seem more in fitting with what would be normal practices. And perhaps with the add-on to that, that there be a request for an extension, if appropriate, which should not be unreasonably withheld. So if there's a voluminous request that can't be met within 30 days before they subpoena, that there'd be a right to ask for some extension for cause being shown. But there shouldn't be, you shouldn't be able to stall an investigation by just dragging your heels. And if they have their own independent access to records, it should eliminate some of the tension that has existed over this issue.
Any discussion on access and or support input? Yeah, Tom?
I mean, I agree with that 100%. It did come up in, even though it's not really in the jurisdiction of our subcommittee, was something that I thought the provision was odd. And so I did ask a lot of the witnesses about that, and I didn't hear anyone defending the need to give people 90 days. I mean, but the time to do certain things, but I see no need for their, especially because you're not just trying to get document agencies, but also contractors who are outside of the government from time to time, and why they should be able to put it off automatically for 90 days. I just don't see.
Anyone else want to weigh in?
Mr. Chair, I'm just trying to understand. So the current code says, may you issue a subpoena if no compliance within 90 days. I mean, that's a paraphrase of what the code says. So is the idea that we would make the subpoena power after only 30 days? I'm just trying to understand sort of how do you tweak what the code says to achieve, and I agree with what you're saying. I mean, it's more of an implementation question.
But the funny thing is, this was not a topic of great discussion, if any discussion whatsoever. I think it is an implementation thing, though. I mean, 90 days just strikes all of us as unreasonably long. I mean, I think if you change that to 30 days, unless further extension is granted for good cause shown, something like that, is sort of consistent with what would be, under any existing administrative rule or code kind of thing. Because I think what you want to do is encourage prompt compliance, but recognize that there may be circumstances where there are reasons that it takes longer than 30 days to get some records. But I mean, that provision strikes me right now as being adopted to protect sort of the outlier circumstance where you leave a long period of time. And in a lot of instances, what was being anticipated or requested is fairly succinct and straightforward.
So the way it's currently written, it sort of sounds like it would also restrict utilizing subpoena if, for whatever reason, and this may only happen once every 5 to 10 years, but when you need immediate access to materials, because of the type of investigation before anyone can make, substantive changes, et cetera. And so, how can we also protect against that happening?
I have a question, if we could go back for a second, because I'm just not clear on the unrestricted access to materials. And so is there a limitation on that? Is it depend on what the investigation is, or it's I'm not clear.
I mean, the testimony that we heard on that issue is right now requests for information all get funneled through basically OIT. I mean, primarily if you rent access to county records that you go through there. And that requests that were to agencies are getting funneled there so that they all get coordinated in one way. But it can be perceived as a way to sort of track the investigative actions of the OIG, which, I mean, there should be independence. They should be able to access records. There's no reason that we heard that they couldn't independently access the same records. So the notion was that they should have their own independent way of getting access to what are just standard county records, which I think is consistent with best practices and practices in other areas.
Okay, let me ask, let me be clear. So are we saying that an IT system that has several requirements about sensitivity, the holding of records, that an IT system that an IG's office can independently go into an IT system and pull an employee's email? Is that where, I'm just using that as an example.
Yeah.
But is that what you're saying?
Yeah.
Okay, I think I would need to have further consideration and understanding about that. I'm not comfortable with that.
I mean, I would say just right now, the IG, I believe she's requesting records through the custodian. If the custodian of records is giving, like, she's already receiving that information. So all we're saying is that she does not need to go through an additional loophole of requesting it and waiting, where now different department heads know that she is looking into their information. So this is nothing different. It's just we're removing this one barrier that delays this unnecessary hurdle. She would still be required to protect those records, and no one would be able to request that information from her, which, you know, would lead to, you know, her needing to redact information and so forth. So anyone else who wants to access those materials still would have to go through the actual county's custodian of records. We just don't want her department to have to do that.
So so where would the check and balance be? Because that is, now from a federal standpoint, a custodian means something. That is a really important part of their job, is to be a custodian, as you mentioned. So where is the check and balance with that if there's just the ability for an IG to have unfettered access to any record at any time?
I mean, I'm looking at the comment right now, which points out, and it's a valid comment on health department records, for instance, where there are HIPAA restrictions. I mean, it seems there are certain types of records that there's certain sensitivity to. I don't know how those are currently segregated within the county's, you know, IT structure. So, I mean, it would seem to me there would have to be some further discussion around the implementation, because I mean, your point's well taken. For the just normal sort of day-to-day records that you're going to get now and she's getting now, getting them independently makes sense. But there may be certain classifications of things that are protected within the county's IT structure that would need to be specially considered.
Under the current statute, I'm assuming that the custodian of record is required to give whatever information the Inspector General requests. Is that correct? So the requirement is already there, and I don't know whether there's any penalty for not doing so.
Yeah, Mr. Chair, the section basically says, A, the IG has powers to get this stuff. B, everybody must cooperate, and if you don't, you're subject to disciplinary provisions of the personnel law or provisions of any applicable collective bargaining agreement. And C, the IG may issue a subpoena if you haven't gotten compliance within 90 days. So the subpoena process, it doesn't contemplate that you issue. I mean, I don't know how it works. I'm not a litigator, forgive me, but I don't know. There's no power to issue a subpoena on day one. You issue a request on day one for which there is the implied not the implied, the explicit requirement to cooperate or face penalty under the things that I mentioned, whatever those penalties might be. And then it further says, if you don't get that after 90 days, you can issue a subpoena, which it then says may be judicially enforced. So, it's kind of a fairly tidy structure, whether the timing works and also whether I have no idea what the answer is to whether everything the IG can get is somehow limited by certain things, like, for example, some sort of federal law that says you can't. I just wouldn't know where to begin. But I'm sure that the IG herself or somebody at the county could tell us if there are exclusions to what is otherwise a very broad power. But that's the basic structure. You can get this stuff. People that don't comply are subject to discipline. If you really don't get this stuff within 90 days, you can issue a subpoena and you can get judicial enforcement.
So it sounds like the greater issue is the 90 days then. No, Kathy?
I think the independent access and how that plays and how that as a practical matter is implemented is the greater issue. Like, I think the 90-day thing, whether that one of the comments suggested it should be 45 instead of 30. I mean, I think that's a tweak to what's there.
Mhm.
I think the implementation of how independent access actually works out, and are there subcategories of records that require some extra protection, and the health department example is a good one. There's some social service records that would be another one, where there are federal laws that mandate confidentiality of reporters and things like that. So, and I don't know within the county's record keeping system now how that stuff is flagged in a way that those protections are preserved. It would seem to me under the law that presently exists, the IG has access to those things, and there's no, that level of detail isn't addressed in the current structure. And to John's point, how that would play out in a court system is you ask for records, somebody doesn't comply, you issue a subpoena, the non-compliance, there's a motion to enforce or a motion for a protective order based on some provision that says even though you have broad access, you're not entitled to look at this specific thing. So it may be that there are certain categories of documents that just get walled off because there are other protections. But I don't know enough about the county's, record keeping structure to know how you fine tune the recommendation.
Well, I would say that would be the custodian. It should know that. And so you go to the custodian with the request, the custodian responds to it. Certainly then we've short-circuited a whole need for a subpoena because the custodians presented the argument or the position, this is why you don't get it. Here's the legal reason why you don't get it. If there needs to continue to have that, then fine, but you don't have to get to the 45, 90 day to find out why the custodian is not providing the information to the IG.
I mean, the interesting thing on this topic, though, is that the county attorney weighed in on this specific issue. My recollection of our discussion, and I turned to the others, was supportive of independent access to records.
Joanne, I see, looks like you have a comment.
No.
Oh, okay, okay.
I was agreeing with the judge. I believe that is what the county attorney said. And I'm not sure the custodian, I'm trying to think of examples. The custodian is only redacting or denying records when it's coming from the public, right? So not the IG. I can't think of an instance where the custodian is not handing that information over. So, yeah.
Yeah, because it's public disclosure of things, not internal and investigative.
The subpoena power provision in the code, if I'm understanding this correctly, seems to be suggesting the ability to subpoena from outside of the county. So I'm a little confused on that part of this discussion. It seems like our discussion has been talking about getting county records, which has been a bit of has been an issue apparently. But I'm thinking that these rules that we're talking about with subpoenas, it feels like if this is in fact, if the code is in fact talking about subpoenaing from outside of the county, that requirements here with respect to timing and other kind of pieces of this, maybe need to be different when you look at inside versus out of the county. Anyway, I'm confused on that part of our discussion.
I never understood that. I mean, again, I'm not a subpoena lawyer, but I've never really thought much about the difference. I just assumed that you can imagine situations outside, certainly, and regrettably inside sometimes, where a future county council member or a county executive says, "I'm not giving it to you," and if the penalties are the discipline provisions of the personnel law or the provisions of any applicable collective bargaining agreement, which probably don't do much with respect to elected officials, that you could theoretically, someone, judge, maybe you would know, or you could have a subpoena issued to compel a member of the county government to produce something. I assume that would be less likely, but I think it's probably there to provide a remedy both externally and internally if it should become necessary.
And the judicial remedy of it's a contempt remedy. I mean, if you issue a subpoena, if the IG has the subpoena, the authority to issue a subpoena does not complied with, then the remedy for non-compliance is a file a motion to compel, or a request for a petitioner for finding a contempt for failure to comply.
So an example of one of the questions I have is if we're going to talk about what the period of time is that you have for responding, and Judge Cox was talking about, 30 days. So I do think that we need to be saying that, and certainly it should be, in my view, 30 days for coming outside. Because the odd thing here is that although the code says that subpoenas issued by the office may be judicially enforced, which suggests that the IG can serve a subpoena on an outside person, perhaps the issue has to do with some sort of a payoff alleged to have taken place between a county employee and some third party. And perhaps the IG wants to subpoena that third party. And now the IG, when she does not, or he or she does not get the documents, wants to go to court. Then, unlike a subpoena issued by the court, you are here without there being rules such as when the way it is right now, the rule regarding when the response has to take place, or whether you can object to it. I wonder whether a way to deal with that would be to say that a subpoena needs to meet the requirements, the procedural requirements of a subpoena served, issued under the Circuit Court for Baltimore County, just to have there be a set of rules, perhaps.
Kathy or John?
It will build in additional delay. I mean, you could change this to say authorize the Inspector General to apply for the issuance of the subpoena for the production of records to the Circuit Court. Yeah. It does then, and Cindy's right about this, it would then put you within a set of rules and a procedural context that would then govern enforcement more clearly. It would clean it up. I mean, and it's the point's well taken in terms of outside versus interior production of records, because there are remedies within it for noncompliance with if you're a member of county government and there's an obligation to produce it under the county code that applies to county agencies. But there are circumstances where you'd be looking to get compliance from somebody who's not technically a county employee or an agency.
Okay. So it sounds like perhaps some further information or fact gathering needs to be done on that subject.
Yeah, and it may be worth, I mean, going back to the IG's office and see what issues have they, this level of detail did not come up in any discussion as a problem that's occurring. The discussion revolved around getting access to county records and sort of delays in that process and the way to avoid it by more direct production. So.
I would also just add that maybe this goes to a climate question too. If the county employees in general are not complying with an IG's request, then maybe is there a disconnect in education? Is there a disconnect? Is there just non-compliance because they don't want, what is the disconnect, or is there a disconnect about the climate of the county that people won't comply?
We did have a series of recommendations around this topic, which was not one of the topics assigned. And if you want, we can kind of talk about, I can segue into that right now, because I think that, or I can do it at the end, whatever your preference is.
I don't want to take you off the agenda item. So maybe that's something we'll come back to.
Okay. So again, it sounds like we need to do some more work around that area, and we can do so. And it may be further clarified as we move forward. So we will move forward and come back to that later on. So we'll move to draft report notification and response period.
Okay. On this topic, there was a fair amount of, in the interviews that we had with people, there was a fair amount of discussion around reports, the way they were received, the information that was obtained, how it was obtained, and how the reports were done, and then the response period. There were, and a lot of that, had to do with sort of very specific instances. And I don't think it's productive for our discussion to get into sort of what happened in this case or the other case. It really made us kind of just sit back and look at policies and procedures generally. One of the things that's noteworthy is that and I say that, I preface this by saying, I think the Inspector General has done a great job of sort of developing materials for an office that's been created, out of whole cloth. So, we're still in a growing process. There's a policy and procedures manual that has been produced to us that is marked as confidential. When you go on their website, you can't access a policy and procedure manual. And my read of the one that exists is it's more of an internal manual for how they operate, as opposed to something that is available to the public and what they should expect. There's been tension around the policies on reports. And I think if you look at the basic intent when this office was formed, it's to increase, accountability and oversight. It's important that reports that are issued are done so that they're factual, they're accurate, and there's not this kind of back and forth in a response and reply saying, you didn't ask this person this, this is inaccurate. So where we came to after a lot of discussion around this topic is the current practice is to issue the report, get a comment, then it gets published. The question that we throw out is, would it be a better practice to have a draft report issued with a 30-day period for comment back, asking for corrections, further investigation, further consideration, so that before something is actually published, there's an opportunity to provide additional information if they feel that, if the county or the subject of the report feels that things were either overlooked or misstated, correct it before it's done. So our belief was what should be issued was a report with a comment on factual inaccuracies, if any, or request for further investigation, which the Inspector General would have within their discretion. They could do it or not do it. It's their, discretion to respond however they think appropriate. Then issue the final report for final response, and that they be published simultaneously. The other thing that we noted is the way they are published right now in terms of on the public website. The report is almost, the response is appended to the report. I think it's important that, we think it's important in terms of best practice, that the website be such that when people are looking for information, you can see what happened, a report, a response. In recent practice, there was a reply, and I think it's important that what we develop in terms of recommendation is what the practice is. A report, a response. We're suggesting that they be issued for comment on accuracy before they're actually made public, and then posted in a way that there's just one report, one response. That's the end of it. Because, I mean, we're talking about public trust and confidence. I don't think it, you may not agree at the end with conclusions, but the back and forth, it doesn't seem productive. You put out an accurate report, you put out whatever the response comment is, and that's the end of it, and we move on. So the other thing we talked about on this topic is confidentiality within reports. We did get comments about information being presented in a way that either a name was put in a report or there was enough identifying information that's clear who the report was about. The code right now makes it clear that that the name of a complainant is to be kept confidential. It's really silent on protecting the names and identities of witnesses or other people. And the current policies and procedures that exist leave it indicates that it's within the sole discretion of the Inspector General whether identifying information is or is not included in a report. While it is hard to write a report that's clear without sometimes providing information about where a person works in a way that perhaps some people can figure out who it is, we do think that it's important to promote an atmosphere where people who wish to talk to the Inspector General can do so freely and without concern of their identities being out there or there being retaliation. So we think that we should strengthen, that there should be a strengthening of the language around confidentiality to include those who have been witnesses or have cooperated in the course of an investigation or provided information.
Judge, Mr. Chair, may I ask a question?
Yes, certainly.
Judge, you probably didn't look at this and maybe somebody else can, but I presume there's like a best practice way to do this, right? Or, Janine, you've done this, Mr. Chair, you've done it. I mean, I've certainly read these things and yeah, I guess sometimes you can tell, sometimes you can, and maybe it's not impossible to be perfect, but it seems to me that there must be some, I mean, I don't know what to call them, techniques or rules you use to kind of do that, to provide as much anonymity as possible. And I don't know whether we think that the current reports are falling short of that inadvertently, or whether there's just a point where like there's only so much you can do. And I just don't know how you get to, like, is there a technique that maximizes this confidentiality before you create something that is essentially unintelligible?
I mean, like intuitively, when you read a lot of the reports, it seems that that's what the IG is attempting to do.
Right.
The disconnect is the policy manual says it is within the sole discretion of the IG on publishing employee names, titles, and positions in their published reports, so long as publishing information conforms to applicable privacy and freedom of information restrictions. What's in their policy manual, and granted that manual is not an external manual, but we think there should be both an internal and an external manual so people know what the policies and procedures are. And in talking about what that policy is, it should be the flip of, and this is my view, not a recommendation, but I think we want an atmosphere where people think that they can speak freely to an IG, and that it won't be flipped around on them in a way that's in a published document that their supervisor may not take well to. So I think we need to develop policies and procedures around reporting that promote the notion that the IG is going to use its best efforts to keep individual identities confidential and not publish names.
Okay. So you're seeking some balance between the need for transparency and the need for confidentiality.
Yeah, and to the extent that the current legislation talks about confidentiality as to a reporter, that the policy and procedure manual doesn't necessarily track that through. And I think what we really believe is there's a need for a policy and procedure manual, internal and external, that stresses the obligation, which I mean, I think intuitively they understand and are trying to preserve, but the obligation within the office to preserve people's confidence.
Any further discussion on,
So we're gonna have additional information on that gathered. Is that the idea? Looking at some best practices and what other IG institutions do.
I don't know that. I don't know that that's necessary. I think it's a question of what's the climate we should be embracing, and confidentiality is part of it.
Well, I say that because what does that mean exactly? It seems like it means different things to different people if the redactions are not consistent or then left up to.
Part of, I think the difficulty in forming recommendations is some of what we're talking about are legislative changes. Some of it is almost a best practice suggestion that relates to policies and procedures that are internal to the office. And I've struggled with figuring out how we phrase those recommendations, because I don't think it's the role of this commission to micromanage, how the office functions. But I do think that there's certain things that could be strengthened and safeguarded, which would diffuse some of the tension that exists and improve the functioning of the office. Having a published policy that the office would promote, practices would preserve the confidentiality for people who report and cooperate in investigations is one of those things. Having written policies and procedures that are available to people so that when you get a request to come in for an interview, you have some idea of what's going to happen and what your rights are. Those things, and I don't think we're going to legislate them. I don't think that that's the appropriate way to deal with them. I do think it's important, though, that in our recommendations, we spell out some of the things that could be strengthened, that would reinforce the idea that this is a promotion, it is an important function in county government.
so there is some further work, I guess, that needs to be done around that in terms of kind of massaging it a bit more.
Sure.
I mean, just so I'm understanding though, what massaging, I guess, what specifics are needed for that one? I'm not clear what we heard best practices. And I mean, if that's needed, we can add it to the document, but I'm not, what we're trying to do is develop what we think is best for Baltimore County based on what we've heard. So yes, we know that Montgomery County has done this, Baltimore City, other jurisdictions, but I think it's also an attempt to address some real tension within the county that I don't think we can ignore. And I feel like having a draft, giving department heads time to respond, especially to the factual things that are factually just incorrect that maybe the IG didn't have access to, I think should be a best practice. I don't think it looks well on the OIG's office either when a report comes out and it has data that it is proven to be wrong. So I think it also protects, it helps their office too. But I'm not sure what we're requesting what the request is that we look into.
So, And I guess I'll ask Kathy to kind of help with that as well in terms of a response to that, Joanne, in terms of what we're looking for going forward. And maybe it's just a language thing we're looking for, Kathy.
I understand Joanne's point, because I think the tension in it is how we're phrasing recommendations on certain things. And maybe it was with our subcommittee, the nature of the things that a lot of the things we were looking at are specific practices and procedures of the office. I think the overall recommendation would be that there be a policy and procedure manual that's both internal and one that's external, that's accessible, and that it addresses the specific policies of the office in the following areas. And, maybe I don't think it's necessarily our place to micromanage all of them. But I do think it's important that there be a clear policy on confidentiality and preserving confidentiality in reports. I do think it's important to have a policy and procedure, and we'll get to this later about, how are interviews conducted. And, there are things like that that should be spelled out in plain English, accessible to the county government, so that people who are dealing with the IG's office know what to expect. And there certainly have been tensions around lack of clarity on those policies. So, we could, and I don't think there are things that we believe should be legislated at all, but there are things that should be clarified to improve the climate in the county that surrounds cooperation and work with the IG.
Does that help, Joanne? Okay.
Yeah.
I think we're within our group, we've had a lot of discussion around this. So I think Joanne,
we're all on the same. Yeah, we're on the same. I guess I was trying to understand, what do other members of the commission need for us to help kind of bring this? Yeah.
Mm-hmm. Yeah. Did anyone go ahead, Janine?
Well, I'm back to confidentiality. What does that mean? Maybe it's just simply, you don't have to legislate it. I believe it's already legislated. So but if we're saying it's something different for Baltimore County, then what does that mean?
Well, the only thing that's legislated is confidentiality of the person who makes a complaint. There's nothing in the current legislation that provides any sort of sense of or any requirement for the Inspector General to not disclose names of people who cooperated in an investigation and other things. And in fact, the policy and procedure manual would suggest that it's within their sole discretion to do whatever they think appropriate. I think as a matter of practice, they have worked to not bandy about names publicly and things that are going to be published, but there's not a policy that states that. I think it should be a stated policy so that people know when they're talking to somebody that their name's not going to show up in a report. It's that sort of best practice suggestions that the policies and procedures of the office be fleshed out more clearly, and that there be an external policy and procedure manual so that people know what to expect. Because I think what will happen if it is external is that to the extent that people have, complaints about a policy, it'll get vetted. Right now, all of their policies and procedures are internal and confidential.
Okay. Are there any protections in the statute for persons who are other witnesses or who have filed complaints? Are there any protections against retaliation in the statute?
There are protections against retaliation, yes.
Okay. Okay. But having worked in government, we know how precarious that can be. So, not in county government. Let me say that. I know we have people from the public. I'm not speaking of Baltimore County. I never worked in Baltimore County government, so I'm not speaking of Baltimore County government. Okay. So, That, okay, so with regards to the draft report notification and response period and the written policies and procedures, would ask our note taker, and I know that they have taken notes on some of the suggestions that you have made, and we'll kind of massage the language of that. And of course, when we come back in our next meeting, we'll, talk more about it as recommendation. But go ahead, Kathy.
Can I ask if anybody has any other comment on this, the notion of having a draft sent for comment before you do a final?
The only comment I have or would be to, what does the policy say? Is there an internal policy that speaks specifically to it?
No, we're suggesting that the policy, that we would recommend that a policy be developed so that a draft report is issued for comment before it's finalized in public. And in response to the draft, that particularly on factual matters, that the Inspector General would then have the discretion whether to reopen their investigation, correct a report, or take further action before finalizing a report. So that if there are circumstances where there are suggestions that pertinent information wasn't reviewed or received, or that there's an error in a conclusion that was made, that all of that be done in a draft phase before you have a final report that gets published with a response, where people are sort of airing inaccuracies in public documents.
I'm sorry, Janine, go ahead.
No, it's just a procedural. Go ahead.
I don't really know what the standard practice is here because it's not an aspect of things that I have looked into. What you're saying, Judge, is obviously intuitive, and if it leads to a better report and allows factual issues to get vetted, and for the IG to say, "Oh, thanks, I didn't realize that," or whatever. But I'm also worried. I mean, so I guess my question is, what's the downside? And have we thought through it because the upside's clear. Question is, what's the downside? And if the downside, my concern is frankly that it sets off a firefight about the report itself. You're now giving notice to the whoever, right, that there is this report that's coming up that you didn't know about, and here's this thing, and it says that an important person in the county has done these things based upon these facts, and all of a sudden it just becomes a battle over, you're not right. Yes, I am. No, you're not. And I mean, I just don't know what that looks like. And maybe that's okay. Maybe it's not going to happen that often. Maybe, again, I think in a lot of cases here, and I made the point earlier about another aspect of it, which is, we're not picking a perfect solution. We're picking the better of the two. We're picking the path of that sort of achieves the most and risks the least, or whatever. And certainly the good paradigm of what you're describing is you put the report out there and someone says, "Oh, no, you don't understand. Let me explain this to you." And the IG says, "Oh my gosh, thank you, because wow, we really," but a report that is inflammatory, as a lot of these reports are, or controversial, you run the risk of it becoming just a battle where someone says, what can we throw at this to make sure that it never sees the light of day? And maybe the answer is, well, give it your best shot. The IG still has final approval, and you have a period of time at the end of which the IG says, appreciate the campaign you have waged for this report never to come out. I've made 5 of the 2,700 changes you suggested, and now I'm issuing the report. It's just a balance. But I mean, I'm trying to think through what if anything is the downside to what on its surface seems like a totally constructive and reasonable, sort of suggestion for improvement in the process.
I mean, the downside is delay, because it will take longer to get the final report out. But there certainly were comments that we received where people thought that there was a lack of, whether there was or there wasn't, there was a perceived that, certain people who should have been interviewed weren't interviewed. There was lack of understanding of how certain policies had been developed. And, it is hard to plunk yourself in the middle of county government and get it.
Yeah.
And so there were certainly some agency frustration that they would have wished to had a fuller conversation around certain things before reports were coming out.
Right. If only you had let us explain.
Yeah.
Kind of thing. I know,
And-
right.
and-
and that's the upside. I totally get it. I mean, I'm not opposed. I'm just trying to figure out whether we're solving an issue and creating another, but I don't really know. And I wonder if other people have a view of that, or if we should ask other people, including, for example, the IG, like, just look, we think we might want to do this, but, what's the downside? And maybe whatever it is, and, you just have to, like I said, you're picking sort of the best path you can to address issues. And if it creates some collateral issues, then that's just the price you pay.
Through their processes and procedures, do they not have a process where the appropriate office would review the finding, or the information, seek clarification, or go back and say, is this accurate? No?
No,
Okay.
they issue a report and the county can issue a response. And there's been tension around how much time they get to issue a response.
Right.
And, our suggestion is, pick a number. It's 30 days, 60 days. I mean, we're suggesting that it be a definitive time frame with request to extend for an additional 2 weeks, which, not to be unreasonably withheld. So you get it, but there were a number of comments around things that people believed were not fully understood or vetted. And
Right.
I'm not saying that that's true, but
Right.
there was a perception. And then you get a written response that says you didn't talk to blah, blah, blah. It would be, I think, productive to not be having that back and forth. If there's a legitimate flaw in the process, fix it before you're issuing a report. And if there isn't, so be it.
And I would agree with certainly wanting to issue an accurate report. It was a process question that at some point in the process that there's not that check on knowledge, and before one would issue a final or a draft report, that you would check that. You go back to the source of the information. Is this accurate?
If that is a practice that they have in some way, it's not a defined practice.
Okay.
I mean, and I don't mean to imply that they're not trying to get it right. I think they do, they've
Sure.
done, it's
Right.
not, it's a way of, I don't think it's productive to debate accuracy of facts. Everybody wants the facts to be right.
Right.
Can I ask one other question on this, which is, one of the benefits of doing what we're doing is that by and large, we're not doing any of this for the first time. What is the normal path? Like, what's the best practice on this? Is there a draft period and a private draft period, or is it not typically the case?
I mean, I didn't see that in any of the stuff we've got.
Be good to know. I mean, I certainly, if that's missing from here and it's an ordinary thing, because this issue comes up, I think it must come up all the time. It's come up a little bit in my world from time to time where people can be frustrated. And I just wonder how the balance has been struck in the rest of the world, in which direction. So is it possible to get to the bottom of that a bit?
I mean, I don't know in terms of the Schaefer Center's research or whether they've got an ability to find that. There's a lack of detail on this process in all of the things that I've reviewed that we got, including our own internal stuff, And it may be the suggestion to go back and have further conversation, both with the Inspector General and with the county's administrative officer on, is there a way to tweak the process so that it would work better? And not be doing this just making it up because it sounds good to us. Like, I think the further discussion around it makes some sense, but there are ways to improve the process over what it is right now.
Okay. Any other discussion on that? I think So again, you've covered, I believe, draft report and written policies and procedures, Kathy. And so we can move to communicating about new investigations, which we kind of probably segue into that with county or agency leadership.
It generally, the comment on that is that, I mean, the independence of the investigation and preserving the independence of the office is an important principle that we need to protect. There were certainly comments and people who came to us who felt that that the IG should sort of follow a chain of command and notify, supervisors before talking to employees, and notify heads of agencies of pending investigations. On balance, our group was not recommending we make some suggestions along those lines, that preserve the independence of investigation is important, and to require or mandate that there be reporting on pending investigations sort of undermines that principle. So the only corollary which we talked about is that so far the office has issued investigative reports. There is another part of their, the investigations of fraud, waste, and abuse is a big part of what the office is designed to do, but it's not the only function that's in the statute. And there's little in any of the policies or procedures or the statute itself that talks about, the other role that they have. So whether those policies should be developed is a question. And I'm looking for, give me 1 second, I'm looking for. There's reference made within the IG's policies and procedures manual about management reports, which would seem to go to this other mission which they have, which is to develop ways to promote efficiency and accountability and integrity in county government. There's some mention of it in their internal policies, but the legislation itself says little about that other than that that's a function. And there should be some policies developed around what types of things or more properly referred or internal, an internal management type of report that goes to efficiency, accountability, and integrity in county government. One of the things in making that distinction, one of the policies and procedures we looked at is that in Baltimore City, it had very specific prioritization of what matters should be the subject of an investigation and what should be given priority in the office. And we thought that that might be a good policy to consider adopting. I mean, it's in the Baltimore City policy and procedure matters. And it prioritized matters where there were significant city decisions awaiting completion of investigation, matters which were complex criminal activity or involved multiple subjects, matters involving high-level city employees, high visibility programs, other things like that, that it made sense to sort of talk about what are the priorities for investigations and have best practice sort of develop that as part of a policy and procedure manual. And similarly, to flesh out the policies and procedures around how the office works to promote efficiency, accountability, and integrity in government, which is something different than an investigative report. So on the specific topic, should they be reporting and telling what they're investigating and going through a chain of command? No. But there are corollary issues that in terms of strengthening the office, it would help to have the office develop and define policies around.
Okay. Other discussion around that subject? Sure. So does everyone generally agree with what Kathy is suggesting? I'm not hearing disagreement, so I'm going to assume that means this general agreement. Okay. With regard to rights of investigation witnesses, and I think you may have touched on that a bit, Kathy, but
I touched on it a bit, but the one area that I haven't touched on is there was discussion about rights to counsel for investigative witnesses and whether the county should be paying for counsel for investigation witnesses. It was our general belief that people should have the right, that in a policy and procedure manual, it should spell out what people should expect when they're called into an interview and what their rights are, which would include the right to bring counsel with them. But in terms of county paying for it, we were not endorsing a policy that the county be required to pay for counsel. They did think that it made sense to have an opportunity for an individual who felt that they were somehow aggrieved in the process and that they had to retain counsel to be able to petition to ask for reimbursement of funds. And it would be within the discretion of the county, and whether it be the county executive, the county council. We didn't get into the nitty gritty on that, but I think that we thought that there should be an opportunity to be able to petition for reimbursement of funds, but not an expectation that, you know, everybody being investigated or everybody being asked to cooperate can get counsel and have the county have to pay. So that was one of the areas of recommendation in terms of rights of witnesses. And it might make sense to do these sort of really. So I don't know whether anybody had any comment on that piece of it.
okay.
The second, we had a lot of discussion around recording of interviews and whether interviews should be recorded. Again, our belief is we shouldn't be telling the Inspector General how to conduct their investigations. But we do think it's important that they have policies and procedures that outline how people should expect investigations to be conducted. They have policies, and it appears that they have evolved to a point where their general policy is to record interviews. And with Maryland being a 2-consent state, they've had some, there've been some tensions around how that gets implemented. In their current policies and procedures, they have, in many instances, statements that as a general rule, we will do whatever, we will do X, Y, Z. Our suggestion is that they develop clear policies and procedures around how interviews are going to be conducted and define what an interview is, because there was tension also with what are meetings, what are interviews, and what role am I in? Around interviews themselves, the suggestion was that the term be defined, and as an example of that an interview is a meeting being conducted to further an investigation that's been opened. So it's not when you're trying to figure out whether you're going to open something or not, but you've opened an investigation and you're meeting with people to obtain information in support of an investigation. That would be an interview. That a person be invited to participate in an interview. They be told that this is an interview for an ongoing investigation, and that these, there's a policies and procedures that are online and available to you to know what to expect. That there be policies and procedures that would roll out in that fashion, so that they would know that they would have a right to bring counsel with them. They would know that the policy is to expect that the interview be recorded, and in the event that you don't consent to a recording, that note-taking would occur, that we don't give out copies of recordings. They have a number of policies they've developed. We think that they need to be clarified and put in an external place so that the person that's the subject of the interview knows what to expect going into it and is clear and unambiguous. I don't know whether there were any questions around that piece of it or comments.
The only question I have with regard to recording of interviews is whether or not individuals being recorded should have a right to copies of the recording or access to the recording.
The current policy, their current policy is not to provide copies and to tell people they cannot get a copy. We thought that there were legitimate investigative reasons to have that be a policy. And again, it falls into sort of the area of not micromanaging how they choose to investigate. So I personally understand why they don't want to publish, to hand out copies of recordings of interviews. Somebody, if it's an ongoing investigation, you can provide a copy to somebody else to know what to expect and go into a meeting. I can think of all sorts of legitimate investigative reasons not to want to have the recordings being provided and available to a person. So I think as in other areas, where we fall on this is, I don't think we should micromanage their policies, but I think they should be clear and unambiguous and stated so people go in knowing what to expect. And that so the IG's office isn't continually answering a series of questions of, why are you doing this? Why are you not doing this? I think one way to avoid some of the as a general rule policies, I think leave them open to this continuing sort of, why are you doing it this way conversation. Clear and unambiguous policies that are available externally, I think will support the office. And also you would be able to train people on what to expect in dealing with the IG's office. This is how it operates. This is why it operates.
Any further discussion with regard to any of?
Yes, I have a maybe it's a little more of a general comment, or maybe it's like a sort of put a pin in it comment. Two things. One is, I'm extremely sympathetic, in fact, supportive of the idea that we're not going to micromanage and that we're not going to write their policy manual for them. I guess the question is, are there in our recommendations going to be, we're not going to do that, but here are 3 or 4 sort of things that we think, some principles that we think need to make their way into the policy manual. And I don't know exactly what those are, Judge, because I haven't been thinking about it, quite as much as you have. But it seems to me that we don't want to go, and I know you're not doing this, we don't want to basically say, our recommendation is that you should write all your stuff down and be clear about it. Because I think we have to say, at a minimum, you should write all your stuff down and be clear about it. But we also think that we've heard from enough people to think that the equities would be better served if certain protections for the protection of witnesses, blah, 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 were in place, including A and B and C. And maybe it's not A, B, C through Z, but maybe it's just A, B, and C. And I don't know how to put meat on that, but that's the anxiety that I have about this. I don't want to stop just by saying, as long as you're clear, that's fine, because I don't think that's our job. I think our job is, at a minimum, you need to be clear. And then we also think there are a couple of things you might want to do a little differently or a little bit better, assuming that the facts and the testimony that you have heard, that we have heard, are there to support those conclusions.
And I've struggled with this a bunch because I don't think it's our job to micromanage. But I do think that there are clear tensions that exist. And it's a new program, and it's, everybody's trying to strengthen it because you want it to work well and you want it to succeed. I struggled with, in terms of recommendations, what this looks like. And in my mind, the best I've come up with is that we recommend that there be, an internal and external policy manual, and it would be best practice suggestion to include conversations or, a discussion around the following and list topics. And then the back end of that depends where you go as to whether there's an oversight board or not, or what that structure is. Because having someone external to the office look at it and critique it for them to do with what they want is not a bad idea. But I don't know where we're going on that latter topic.
Okay, well, I mean, that's why I say I just want to mention it. And the other thing, which is definitely a put a pin in it thing, and someone can remind me what the schedule says, but we've just spent a lot of time talking about the fact that the IG needs this idea about, for example, the draft report to get it right, get feedback on the ground, et cetera. Maybe the IG and the administrative officer need to get together and sort of think about something. And so I don't remember what sort of draft period have we built into our ultimate report, because it's not just the public, it's certainly the public, of course, But in addition, I do want an opportunity for the IG or the administrative officer or whoever the other person might be to say, you know, you're not living this every day and you sort of missed the point. You know, here's how it really works. And I want to make sure that we do that. Otherwise, I don't want to have recommendations, Mr. Chair, that are like theoretically good, but really don't take into account. So I think we have a draft period, and if not, we ought to, and we ought to use that as an opportunity to get, you know, it's sort of a reality check. It's a little bit, Judge, like what you were saying, where, you know, it's our report. We're going to decide what that report says. But if someone could say to you, you've totally missed some predicate for this point, and here's what it is, and it might affect the way we think about it. I want to make sure we have a chance to do that before we issue sort of a final report where people say, you guys don't really understand how this works, do you? So I just raise that for the sort of, you know, further discussion at the appropriate time.
Okay. And I know that there is a period for an interim report, but in terms of where we would go with that, I would need Ann to maybe weigh in on that to make sure I'm speaking correctly on it.
There is an interim report that's due in December. I believe it is the 16th. And then there's another 1 month period approximately until the final report is due. So we have that period where we can collect feedback.
Okay, well, I didn't mean to disrupt. We can talk about that feedback plan at a later date, but I think that feedback there are a lot of different potential stakeholders for that feedback, and we have to think about that. But let's leave it for now. Thank you though for listening.
Certainly. Thank you, John. So Kathy, were there any areas that we missed? You had a number that going through.
On the, not on the agenda as it exists, I don't believe. There certainly are some other areas that we had some recommendations around, but those I think cover the agenda, but there are other that go back to the other committee.
Okay. Okay, so so let me stay on the agenda, and then we will have opportunity to come back with additional, if that's okay. And yes.
Yeah, I thought you were going to call on us to move forward with the agenda.
Absolutely.
Okay, so it's over to John for number 12, oversight of the IG.
I'm going to do a little bit of what the judge did by combining 12 and 13, which happen to be one after the other. One is about oversight, one's about advisory board, because to some extent they represent a continuum of the same issue. I think first of all, our group and our hope for the commission is that we will strongly ratify and reaffirm the independence of the IG. It's a fundamental principle of IGs in every respect. And we absolutely have to ensure that the IG remains independent. And we've talked about that in other areas, the financial independence, the legal independence, and so on and so on. So independence is absolutely paramount. And that sort of, you know, the question of oversight is in direct tension with the question of independence. It's certainly natural for some individuals who are subjects to want more oversight, but frankly, at the end of the day, the independence is probably more important. There is a remedy in the code now for addressing concerns with an IG, but it's a fairly nuclear option, and it's removal for cause, with the county executive and county council essentially agreeing upon that. So there is an option, but you know, it's a fairly difficult option to exercise, but it's there. There also, of course, are terms. The IG has a term, and the IG has term limits. So again, there are some sort of controls, but beyond that, it's very important not to impair the day-to-day functioning of the IG as an independent entity. There's best practice. There was a nice paper that was supplied to us by the Association of Inspectors General, a position paper entitled Independence of the Inspector General, Management's Oversight Role. And it talks about general supervision as a well-recognized concept, but it says the concept of general supervision should not be construed to impair independence. It should in no way delve into the operations of the OIG. It talks about nominal supervision, which it endorses, or at least permits, such things as requiring the OIG to use the organization's administrative procedures for human resource administration, budgeting, logistics, and so on. But again, always under the banner of cannot impair independence. But it was a very thoughtful summary and guide, and I encourage folks, if you haven't had a chance to look at it lately, to take a look at it. But it does also say, and I'll quote it, this essential independence of IGs raises the fair question of who provides professional oversight of the IG. And it talks about some of the accreditation process through auditing standards from this very same Association of Inspectors General and so on, as sort of a way of reviewing what an IG does. So the current code is sort of consistent with that, in that it requires a review by an outside body every 3 to 5 years, which is, by the way, a very weird way for a lawyer, I guess, to every 3 to 5 years. I don't know why we didn't pick 3, 4, 5, but every 3 to 5 is a little odd. The AIG, the association says at least once every 3 years. So I think we thought that there ought to be, we ought to tighten that up. And once every 3 years seemed reasonable, and that is at least once every 3 years seemed reasonable. It would take away some of the squishiness of 3 to 5 years and have a more regular professional outside review. And we ended up talking about a different question, which is sort of the advisory board question. And again, nobody is suggesting that there be an entity that has the ability to govern what the IG does. That means not their decisions about what to pursue or who to pursue or how to pursue it. At some point, the process has to work in the way that it's been described. And like we've said before, there's a balance here in that you could be unhappy with an IG for some period of time, but that's sort of the price you pay for having the independence. And you do have these, ultimately you have other resources, and you ultimately have removal for cause if you really had an IG who was behaving badly. But it's a very, very difficult and public process to undergo that. So, but we did sort of say, is there a role for some advisory board, some group that could provide counsel to an IG on a regular basis? And what would that look like? And could it be composed of, forgive me, Judge, I wasn't thinking of you directly when I say this, but a retired judge, a university president, clergy, sort of the, members of the community beyond reproach. We all know the kind of folks we're talking about, who could sit with the IG on a regular basis and just give advice, talk through approaches and issues, talk through concerns that the IG is having. And what the question is there any purpose, to having something like that? And I don't think we really resolved that finally. I think we readily resolved that the independence is paramount, that there should not be any opportunity for direction of the IG and his or her day-to-day work, but that there might be a role for kind of a sounding board of the right people, if it would be helpful to the IG and if it would be helpful to the general function of the office. There was a suggestion made at one point that board could also be an advocate for the IG's office, and I think frankly the subcommittee felt a little uncomfortable with that, in that it just started to become a taking sides kind of thing. And the notion of some sort of advisory board is not a taking sides. It's wise men and women, if you will, kind of just saying, well, what are you facing? Have you thought about this? How are you working through problems? But not with respect specifically to the what to pursue, who to pursue, or how to pursue it. So it's fairly, at the end of the day, in the in the sort of fundamental triage of things we should change and things we shouldn't. I think the tentative recommendation is that there should be no change. There should be no additional oversight or supervision. There's no real recommendation, at least coming from our group, for changes to the removal provisions or anything else. The question is simply whether adding to the process some sort of an advisory group could be helpful. But to be clear, it would not be providing oversight, supervision, termination authority, or anything like that. So let me again ask my two subcommittee peers if they want to add anything, and then we would very much welcome your input on the fundamental issue as well as the subordinate ones that I mentioned.
John, I think you summed it up pretty well in terms of our thinking at this point.
Thank you, Tom.
John, just one thing, and I may have missed it. Did you speak to, I heard you mention in the beginning the number of years before there is some sort of review.
I did. I mean, there's the current code says, I can read it to you. Current code says, it's under a quality assurance review section. It says investigations, inspections, and reviews shall be subject to quality assurance reviews by an appropriate professional and nonpartisan objective group every 3 to 5 years, and then copies to different groups. And as I said, to the extent you treat the OIG as kind of a best practice, it suggests no less frequently than once every 3 years. And I do think that as a practical matter, we could tighten that adjustment up a little bit. And I think we could also have a conversation about, whether there should be any other sort of more local review. How often do you need a blue ribbon commission? Is that something that should be scheduled, or should it be ad hoc? But in any event, should be some cyclical review built into the statute that is going to be meaningful.
Yeah, thank you. I thought that was important to specifically capture. In some of our discussion, we talked about the timelines for IGs and how soon they could turn over or not turn over. And we want to make sure that assessments are done to more timely capture maybe what happens in a period. Oh, thank you.
Yeah, sure.
Yeah, I guess the one thing I would maybe add is that we did not think you should take the 3 to 5 year requirement and just make it annual or semi-annual or something like that, because as I understand it, what happens every 3 to 5 years is it's kind of a form of peer review that the Office of Inspector Generals will come in, and that's the kind of professional nonpartisan body that conducts that review. And it wouldn't be practical to have that more frequently, because a lot of resources go into that process. And as part of the process, the IG is supposed to engage in peer review of other IGs, and doing it once every 3 years makes sense, but it may not make sense to do it more frequently. So that's why we were kind of working with, is there another structure that we should have to supplement this or complement it?
Other discussion or?
Was there discussion with the IG as to whether she believes any other, sounding board, et cetera, could be beneficial, or what that would look like?
Yes. Is that subject to the confidentiality of witnesses, or can we discuss what she said about that?
On that subject, I think it would be okay. I think it would be informative.
Yeah, she said that she would like to have a body that would actually advocate for her. She didn't talk about the specific makeup of an advisory board, but in terms of its role and scope is if there was something like that, she would like it to be a resource for her.
I'm uncomfortable with the advocate for piece of it.
Well, I
Um,
mean, I'm just telling you what you asked,
Yeah.
what she had to say about, that's what she had to say
Yeah.
that's my recollection.
Was there any discussion regarding, with regard to the advisory board, who would make appointments to such a board?
No, I don't think we really addressed it in that degree of granularity. I mean, again, we're not trying to create any more sense of tension or oversight. I mean, we really feel strongly, and I imagine most people do, that you cannot interfere in the day-to-day operations of the IG absent, pretty well behavior, that might necessitate termination for cause or whatever else, because, and again, I keep coming back to this question of balance. Do I think that's perfect? Do I think that there might be an IG who deserves to be sanctioned or in some way, course corrected, and you only have sort of a blunt instrument to do it? Yeah, I don't really love that. On the other hand, if the choice is that, or have the ability to constantly be criticizing, correcting, enacting punitive measures on an IG because you're not happy with something, then I guess I would take it the way it is. You just don't have there's just no, you have to kind of pick your path a little bit. And I think this is the better path. There are escape valves for really, really bad behavior. And hopefully that will never happen. And and there are terms and term limits. And in the meantime, you have to live with the idea that you're not going to like everything your IG does. And that's probably just the way it's going to be.
Okay. So I guess I'm just trying to be clear whether or not we are potentially suggesting, recommending an advisory board. I know, and no to an oversight board, but an advisory board. So there's a difference between the two as you've determined. So,
well, yeah, giant. I mean, a complete giant difference. But I think the committee, and again, it's not really the committee anyway. It's everybody. It's an issue that we've all sort of, wrestled with or observed as part of the broader testimony. I think I think those of us who've talked about it, and I'll speak just for myself for the moment, can see a role for that kind of a board, just providing some sort of advice, input, and so on. That's just something people have to decide, and the group of us, whether we want to recommend it as a whole. And Mr. Chair, we just did not get to questions about who would appoint it or anything like that in order to create some sort of, I mean, the equity issue, the issue of appointments seems less important when you're trying to create a board that doesn't have hiring and firing authority and sanctioning authority, et cetera, but merely is there to be a positive, supportive resource for the work of the IG. But you're right, at some point you have to decide. The other thing you could do, I guess, and I think there's been a little of this in the city, you could bake into the code who those members of that board might be based upon, who occupies certain positions in the community, but whatever. There are things like that, but we didn't get into a specific suggestion. I think we frankly wanted to get feedback from the larger group about whether this idea made sense. We didn't want to do something that was, surplus or gratuitous. The question is, what kind of value might it provide? And I think this group thought it would provide some value, and the people we spoke with who thought it could provide some value, as just another sort of actor in the process to try and make things run more smoothly, help to communicate about the mission of the office, whatever. I mean, we'd have to figure out what those things would look like.
okay. Joanne, I saw you.
Yeah, I was just going to say that if we do go the route of creating a board of some sort, I'm not sure why we want to call it an advisory board. I'm not clear what they'd be advising. I mean, maybe it's a compliance board or something like that, where they are looking at the office to ensure that they are kind of focusing on all aspects of their work and not just the investigations. But whatever it is we decide to do, I think it should go through the regular county process, just like any other board and commission. So it should be, we can set some parameters on who can and can't serve, but it should be, the public is invited to apply. There's a period in time, it goes before the council and so forth. And I guess it's we can set it where we can recommend where it's joint. The county executive gets to appoint someone as well, but it shouldn't be the IG's office that is selecting who is going to serve on this body. It should be similar to any other board and commission that's created at the county level.
Let me just say quickly in response, certainly, I don't think anybody would think that the IG, him or herself, would be allowed to do that. When you say compliance, it makes the hair on the back of my neck stand up a little bit, because I think we really are trying to guard against creating any sort of board that could sort of wag its finger at the IG or in any way be viewed as coercive in the slightest period, because I think it's just so important to the function. And I would rather, if it were me, I would rather abandon the idea entirely than risk that we would be creating something that could be viewed as having the ability to influence who the IG investigates, what it investigates, et cetera, et cetera. That's just my personal view.
I mean,
I have to add one. I think we are in agreement. We are in agreement as far as who should not be on the board. If there is an advisory board, no one who is subject to her jurisdiction should be on board. No one from the county council, from the county government, or contractors who work with the county. It needs to be people that she would never have cause to investigate or reason to investigate.
But no board that I'm aware of plays a role in dictating who or what they can investigate. It's not the day-to-day pieces of the work. That's not what it is in Baltimore City. Baltimore City, it's the performance of the IG in the role. And I'm not saying that that's what we need to create here, but even a compliance board would not be that. A compliance board, again, is looking at everything that we're looking at and whether or not the office of the OIG is meeting all of those expectations. Are you only doing investigations? Are you working internally to, improve processes inside and so forth? I just don't understand the advisory. I mean, I don't know what an advisory board would do in an office of the OIG. So maybe it's just figuring out what the entity is, but what advice is she needing? I'm not understanding. Yeah. If anything, an advisory board probably would have more authority over the work that the IG is doing than any other. So I don't know. But it's the advisory thing that is throwing me off completely. I'm not sure that is something that works in this structure.
Well, I think the reason for advisory is to take it away from oversight. We have to make absolutely clear that they're not conducting a performance evaluation or reviewing how she is in her cases, and starting to get involved in reviewing her work product. And
I'm struggling with finding a word for it, because I think that there's, and I agree, compliance sort of suggests an oversight that I think we all agree we don't want to be sort of grading the office or deciding whether they're doing what they should do. But I do think that there's a role that would be beneficial if you had, to provide a sounding board feedback, a kind of, not in the sense of legal counsel, but advice and counsel role. And I would also want to be very clear that if you do it, it's not an advocacy role. You're trying to make that office function within county government the way it was intended to function. So whether, it seems to me their role wouldn't necessarily be limited to talking. There are two sides to how it functions. It could be very beneficial. I just, how you define its mission, and who you put on it would take a lot of, I'd have to think about it a lot more. and you're right, it can't be somebody who's subject to the jurisdiction of the office. It should be somebody who's, you know, in the kind of above reproach category, but also understands how county government operates, and is, you know, astute in terms of just the tensions that exist within all of those roles. You can't just bring in some outsider and plunk them down in the middle of it.
I mean, can it just be a committee? I know, I'm thinking about other programs that we've created. It's a committee that is focused on, with public financing, we have folks that are doing public education. So while her office is doing the trainings internally, externally, maybe they're playing some role there and helping to build confidence and talking about the work of the office. So not advocating for them, but explaining the role of the IG to the public. And other things like that. So adding some capacity to the public education piece. If not, I'm not clear what this, like, what I don't want us to do is create an advisory board or a board that does nothing either, where we've got members of the public, you know, that are serving in a capacity that really is just for show, I think. Yeah.
It's almost more a mentoring role.
Yeah. She needs mentors. Yeah, I don't.
Yeah, I don't know.
Any other thoughts on that subject?
I think in the, I know we're civilians in this role, but we have a concept called the graybeards, who provide, you know, that mentoring and support to a senior leader who might need some guidance or just to think through something without having it be something they're going to hear about later in a free space. And so
I'll just say one last thing, and I don't want to prolong this, because I mean, these are all, Joanne, I understand your point, and I certainly don't want to create something, you know, meaningless. But like, I guess the question I sort of ask myself is, it's kind of a lonely job, right? It's like, who do you sort of talk to? Like, who do you talk stuff through with? Like, everybody you work with is a potential, you know, is a potential subject of an IG investigation. So I just, you know, I think that would it be helpful to have folks that the IG could sort of talk through some stuff with? I know it's kind of squishy, I know, but like, it's just it's a weird role, because, and you know, what would it be helpful for her to have? You know, I think we've touched on it in various ways. The judge said a mentor, you know, and again, I don't want to demean the IG. I mean, everybody needs mentors, right? It's, you know, but just some sort of support structure that could help you reason through something. But, you know, if it's too much, I mean, look, I think the real headline here is, you know, that I hope that this commission is not prepared to recommend any sort of real oversight, you know, body. And, you know, this is like a little bit of a corollary. It's like, well, not an oversight body, but might it be helpful if? And if the answer is no, I don't think it's the end of the world. I just think it was something that we talked about that was worth, you know, discussing and seeing whether it could be valuable in some way.
Yeah. And to be clear on my end, I'm not opposed. I'm just really, so I will go do some research on my end to see what other examples there are. But I know that, you know, her title was changed or her office was changed so that she had that community that you're talking about, right? So it is the Association of IGs, where hopefully they are communicating with one another and she's getting that support, in addition to the office that she'll be building, where she can have a community within her team. Yeah. So I'll look on my end too, but I want to make clear, I'm not opposed. It's just really trying to think about a meaningful word for the public too. That's helpful to the office, but that it's worth opening up for people to apply and serve and put their time onto it, especially if they be limited in their ability to serve on other commissions and boards in the county too.
No, totally reasonable.
Okay. I'm going to move us on. We have about 26 minutes left, and I think 2 areas left to try to cover that we can get through tonight. it would be great. And then we can come back in our next meeting to kind of flesh things out a little more and put the meat on the bone. So the next one then is ethical climate in Baltimore County overall. So.
Okay, I think I'm supposed to address that. That's one in which we have no specific recommendations. There was really some uncertainty in terms of what we were asked to look at. I can tell you that, we did review the ethical climate survey. Some of the findings of that were kind of positive. 86% of people haven't run across examples of fraud and abuse. I mean, so I don't know, but I don't know how that compares with surveys done in other jurisdictions. One thing it means is that when it comes to dealing with issues, if only 14% have encountered it, you have a smaller sample size in terms of what their interactions have been and what their reaction to those interactions have been. I didn't pick up anything in the survey that there are substantial problems working with the OIG. We did hear some of the who had interactions with her, but that's somewhat anecdotal. If you look at the survey itself, it says that 67% had a positive interaction with her. Should it be 80% or 85%? I don't know. But one thing the survey does say is that the reactions to interactions with the OIG is higher than it was with the Ethics Commission or with the county auditor's office, which suggests that there's not a big problem there. There was some concern about fear of retaliation in the process, but it was, a majority of people were not concerned about that, according to the survey. It seemed like maybe one of the biggest issues, and in terms of some of this, to the extent that there is a problem, instead of having a specific recommendation here, some of the other work of the commission might get to this, as the judge was saying that if you're doing a better job of protecting confidentiality and you're doing a better job of employees knowing what their rights are, maybe that'll solve a lot of the problems that you see in the survey. So I guess that's a long way of saying that we don't have any specific recommendations in this area that for action that needs to be taken at this point.
Okay. Any discussion in this area? Anyone else feel like there are some recommendations that should be made in this area?
The one issue that with the two bullets under it was the location of the ethics training, and it was my take on it. That meant to say specifically where would that training reside? Would it continue to fall under the IG's purview in their office, or to move that
Which
with the training to ethics?
Leads into the next issue.
Mm-hmm. Yes.
So, which is, there may be
Please.
discussion about this.
Yeah. So let's move on into that then.
Okay. Our recommendation is in terms of the relationship between the OIG and the Ethics Commission, is we think that the Ethics Commission, the OIG should be decoupled from the Ethics Commission. There's no need for her to be the executive director of the Ethics Commission. In terms of best practices, the materials we're given don't really address that issue, but it is very uncommon for her to serve in that role. The Schaefer Center, gave us some statistics that the overwhelming majority of ethics commissions, to the extent they have them, are independent from the OIG, and I don't see any real benefit of having her in the role of executive director. There is a danger of her being in that role, and that is the reluctance of some people because the Ethics Commission provides advice if you go to them for ethical advice, and there could be some very understandable reluctance if someone thinks there's an ethical issue and they want to get some advice. They may not want to go to a body that's headed by the OIG, because, you know, they may look for advice and then be concerned that it's going to turn into an investigation in which they're going to be the subject of the investigation. So I think it's better overall to have those taken away from one another. And one of the benefits in doing so, to the extent is it does take up a lot of the OIG's time. I've heard it's anywhere from, you know, one full employee to 2 full employees serve these functions. And if you decouple it, then that would free up the OIG and to a certain extent take care of the resources issue, because it would free her up to more of her core responsibilities. The main issue that we haven't decided on is if she is taken out of the Ethics Commission role, they would have to hire a new executive director. But the bigger issue is, where would you house the Ethics Commission, you know, in the organizational structure? And we've done some inquiry on that. We're back some answer to that yet in terms of recommendation.
Okay, you broke up a little bit. So you said you don't have any suggestions in terms of placement yet. Is that correct?
Correct. Yeah, we've made some inquiries and we're waiting to hear back. But you know, we think they should be separated. There should be a new executive director for the Ethics Commission, not the OIG. And we're just not sure where in the county government structure to be placed. But we hope to have more information on that soon.
Okay. So we open up to further discussion. Any further discussion on that? Are you generally in agreement with making a recommendation to separate the two, with the caveat that we will determine where placement, in terms of recommending placement, based on gathering further information? Okay. Then if there's no further discussion on that, we will open it up for, I believe, Kathy, you said you had some others. I'm not sure, Janine, if you had others, or other members of the commission, if you had any other recommendations or suggestions that you wanted to make, topics you want to cover.
The one that we spent some time talking about is how to better integrate or increase the integration of the OIG into the sort of Baltimore County government culture. And in that regard, the county executive signed a code of conduct revision back in 2021. And then I don't think it was ever fully rolled out pending the recommendations of this commission. It was 2021-007, which created an affirmative duty to report, you know, fraud, abuse, misconduct for county employees. It was our thought that that policy ought to be fully rolled out, whatever that means. It was the sense that we got from conversations from the Inspector General's office that never occurred. It ought to be fully rolled out and embraced. And one of the questions we had was whether that there should be consideration for an amendment to the policy that not only created an affirmative duty to report fraud, abuse, and fraud, abuse, and waste, but also added in it a provision that prohibits anyone from, you know, obstructing or interfering with an ongoing investigation. So it sort of provides the counterpart to it. You not only have a duty to report, you can't interfere. And so our thought was to perhaps strengthen what was done, fully roll it out, require, and we asked questions about this. There are trainings that have been done on the OIG's office. I think new employees, it looks like, and we were given a schedule of a lot of trainings that the IG has conducted. But I don't know that there's a mandate that the training on it be part of the onboarding for county employees. There should be a rollout of trainings and ensure that all people who work within county government are fully trained on the function of the office. And again, it goes to the suggestion that there be sort of improved and available online materials for county employees to talk about the mission of the office, how it functions, do it in plain English, make sure it's accessible to all people, so that sort of it becomes more embraced within the culture of county government. Within that, again, we also would strengthen the, or not strengthen, but put within that language that would assure confidentiality of reporters and protection from any kind of retaliation, and make sure that people are aware that that is the culture. So that was an area that we thought warranted some further discussion or recommendation.
Okay. So we're open to any further discussion on that, and I would agree with that. And with regard to the training, I would even say, if it's not already a part of it, that it would be a part of orientation, new employee orientation as well.
Yeah, and I think that there's been trainings that have been rolled out to various parts of government, but I don't know whether all of it have received training. So, I mean, we got a schedule of people who have been trained in the types of trainings that have been going on. There was a lot of new employee, but if all of the little component parts of county government haven't received training on the office, it should be mandated just like any other type of periodic training that we get on, all sorts of things.
I agree. How do others feel about that? And in terms, especially in terms of, as you said, changing culture and making it a part of the culture of government.
Yeah, I think it dovetails nicely with the Find the Ethical Climate Survey, that a lot of people just aren't aware of what the OIG is and what and what the office does. Training, hopefully will go a long way towards that. And part of it's probably just growing pains. It's only been around for 3 years, and people will become more familiar with it. But it can't hurt to jumpstart that with some trainings.
And just as a follow-up and just further thoughts from the discussion tonight, what falls within the ethics role, what falls within the auditor role, what falls in the OIG role. I mean, all of that just gets it doesn't have to be a siloed training. It may be a training that touches on all three of those things, because I think they are interrelated. And I think it's just important to embrace it as part of the culture of county government, that all these, that all of this is important.
Mm-hmm. Yep. Okay. Any other topics, areas of concern?
The one other corollary that I don't think I mentioned before when we were talking about independent counsel and the role, the conflict with the county attorney's office, the question was that we talked about was, to the extent there may be county employees that are looking for advice, that maybe it would make sense for the county attorney to consider assigning an attorney that has sort of a virtual separation from all other kind of OIG work, who could be a person that if people have questions they can go to, who would at least be able to give preliminary advice and refer out. Because we've talked about the need for outside counsel for the OIG herself. But you certainly have members within county government who will have questions. The response to most of them will be, you have the right to get an outside counsel, but at least be able to provide some response to questioning.
And I guess for me, a question would be whether or not this is a person an individual who is subject of investigation, or a person who is a witness who wants counsel. If you're the subject of an investigation, should the county be paying for your counsel?
Well, and I think we clearly are a no on paying for outside counsel for any of it.
Okay.
But you have employees who go to the county attorney's office and ask, what should I do? I work for the county, and you get, like whether there's somebody who at least can answer those preliminary levels of inquiry without being in conflict, I think is a question.
Okay. Any thoughts on that?
Do you mean more than about the process? You mean specifically about maybe an allegation against them, or what they may perceive as a potential allegation, or are we talking, where are you drawing the line?
But and it may whether there's it's somebody who could potentially be a resource, whether for the IG, whether for other who's work in county government without going to outside counsel, who is sort of walled off from the work that the office otherwise does, who could respond to questions and say, yeah, we can respond to that. No, we can't respond to that. We can refer you here. Just a resource that's there in terms of interaction.
Okay. So, but not in the IG's office, in the
No,
county
in
attorney's
the county
office?
attorney's office.
Okay.
Absolutely.
All right.
Absolutely. Who's not conflicted out is the problem they've got right now. They've got all this, they're conflicted out from even having the conversation because they represent them. So can you
Right.
create a virtual separation? So there's somebody who's not conflicted out. So you won't, you don't always have to resort to sending people out. And I don't know how, I mean, none of us had any sense of how often this is an issue.
So an example that occurs to me would be if we are going to be making more definitive a duty to cooperate, which could even end up in a revision to the code. I can imagine there being employees who may not be sure. They know they have this then legal obligation to cooperate, but they're not sure how far that extends. And I can imagine such a person who wants to do the right thing, wanting to get advice from somebody like this walled-off person that Judge was just referring to help them understand what that obligation is.
That brings me back to another question that was brought up earlier, and about the specificity around whistleblower protection. I don't think it was on our list of topics to discuss, but did that need to be?
Okay, you want to add that in whistleblower protection?
What does it say about it? I don't recall.
I think it's in there. I'm trying to,
Yeah.
I think it said something, I just don't.
it says can be no, I know it says no retaliation. I'm looking for the exact language right now. Hold on a second.
There's a section 314-109. You want me to read it or paraphrase it, or?
Yeah, that'd be good.
Anyone who has the authority to take or direct others to take, recommend or approve any personnel action may not, with respect to this authority, take or threaten to take any action against another as reprisal for making a complaint or disclosing information to the OIG unless the complaint was made or the information was disclosed with the knowledge that it was false or with willful disregard for its truth or falsity. Don't know what the penalty for that is. I assume it then somehow flows through the ordinary Baltimore County HR and personnel stuff, not dissimilar to what I read earlier about, I mean, it doesn't say this, maybe it should say this. But you may remember that when we talked about supplying information, there's a discipline provision explicitly that says county employees failing or refusing to cooperate with the office shall be subject to the discipline provisions of the personnel law or provisions of any applicable collective bargaining agreement. I suppose you could, I mean, I don't know if this matters. You'd really need to ask somebody who understands all the county HR stuff, but I don't know why that penalty is explicitly written in one place and not in the other. And maybe that's okay. Maybe it's not. Maybe that's not even the right penalty, but that is the provision, at least prohibit. That's the rule. It's not clear what the consequence is.
So then that would come under, I guess, again, strengthening perhaps whistleblower protections.
I'm not sure we could look at sort of adding some language to strengthen it. I think I think it's covered, but
I mean, I assume that there is somewhere in the code writ large, something that says an employee who violates the provisions of this code shall be subject to, and that this would sort of get read into that, right? There must be some general, it can't be the case that after every section in the code that governs employee behavior, it says, and if you don't, here's the penalty. But someone who knows the code, county attorney's office would probably know instantly. I just don't know.
yeah, I think you're right. I think it has to do with the HR sort of policy. I mean, it goes back to the suggestion we made on the, there was an amendment to the county sort of ethics requirement to make sure that those provisions all were read in there so that they are subject to the same thing. So I think it is covered, but we can look at it again and see if there's any loophole in it, or maybe make sure that someone doesn't think from a personnel standpoint that something else should be required. I mean, the code of conduct was amended specifically to add that employees shall report suspected fraud, waste, or misconduct, and employees making a report. And I know this language was debated a lot, but it says employees making a report in good faith or cooperating with an investigation shall not be subject to disciplinary action for disclosure. Confidentiality will be maintained. And my only problem with this is to the extent possible, which is just very squishy, but at least it I think provides coverage there. And that's the policy I was referring to earlier that just hasn't been fully rolled out.
And you said, Kathy, that's policy, pending policy, is it?
It was signed. It was signed by the county executive. It was my understanding through discussion that it was signed, it went into it is in effect. That there's a way that these policies get rolled out more publicly, and that got stopped when the commission, was created, so that it didn't get fully kind of rolled out and publicized. I don't know what more they would normally do to roll out a policy. I really didn't get into the nitty-gritty of it, but I know it was signed. I know it's part of the county. It is an executive order that was issued. But whatever needs to be done to fully roll it out should happen, in my view.
Okay. So that's potentially a recommendation, either to fully roll out.
Yeah, that was the follow-up. That was part of the follow-up recommendation that we had, was roll it out, do the trainings, whether those trainings also include ethics and audit. If the ethics function is going to be changed, all of it seems to me to be should incorporated in changing in training, and there should be a policy that exists that it be done on a periodic basis and be required as a part of the onboarding process. So it's just incorporated in the culture of county government.
Mm-hmm. Okay. And we want to recommend that any of that be put in statute, or is it fine as an executive order or as policy? I know that's an extra step that to put.
Yeah, and it strikes me as something that's more an executive order than it's statutory, but county legislative process is not my my thing. So it may be worth talking to the county attorney about what's the best way to incorporate that and make it effective.
Mm-hmm.
But and the other piece of that was to add the, and you can't interfere or obstruct.
Okay, we are right at 8:29. So if is any further discussion on any of that? I don't want to just cut us off. Jenny?
Well, only thing, I didn't know where you were going, but I think that there's quite a bit of work left to be done to really, after our discussion. So I was wondering if we were going to be moving towards a extension, or if that been considered by the board.
I think that is something that we will take into consideration. And we may have that need to approach the county executive and to request an extension. So if everyone's in agreement, you know, I want to take into consideration your time as well. I know that everyone on the commission, that you're all volunteering your time, and it is a great sacrifice to all of you.
I agree with Janine, even if it's just an extra month, like it's hard for us to even try and fit in a bunch of meetings right now going into December. It feels near impossible. So any extra time would help.
Yeah, if you're looking for sort of a straw poll or responses, I think this commission has done good work. I think the leadership has been excellent. The process has been transparent, and we're really on our way towards some important recommendations. I don't see any objective external pressure on the timing, other than the fact that we want to be respectful of an executive order that's been issued. And this is, if we're going to get this right and it takes a little bit longer, I can't imagine anyone would object to that. And I'm certainly willing to spend the extra time, speaking for myself anyway. So that's my view.
I concur.
Okay. It sounds like we have full consensus that then we will work on making that request. Okay. So then let me thank you for, again, a very lively discussion tonight and your hard work on the fact finding prior to tonight. And so we will meet again, at least we're hoping to meet again on December 13th at 5:30, where we will continue this process of developing recommendations. And I understand that there may be a scheduling conflict for one or two of our members because Maryland Bar Association has an event that night. And so we do apologize for that conflict. We would like to be able to continue moving forward, however, with the work, even if we're able to get an extension. So we would like to still hold that meeting unless there is, strong objection or, you feel like we won't have a quorum.
I thought we got a poll. We got like a survey where we provided like other dates where we might be available. I don't know if we found an alternative date.
And you can help me with this. I'm not sure that we received enough responses to be definitive.
I don't think that one of the challenges we've been plagued with is that everyone is so busy that it's been hard to get dates where people can meet. So I don't think that we had a date that had consensus. The only possible date we had left was December the 20th.
Okay, and so if we need to do that survey again, and we can just ask everyone to respond, perhaps we can do it that way. And then, of course, we will let the public know when that meeting will be, if not the 13th. Is that fair? Is that doable, Ann?
Yes,
yes,
okay. We can do that.
Okay. Okay.
Appreciate that.
Yes, I'm sorry.
No, I said appreciate that. I know.
Oh, okay.
Yeah.
Yeah.
It's hard this time of year.
Yes, it is. Yes, it is. Okay. Then do any commission members have any other commission business to discuss? If not, that ends our agenda for tonight. And so as usual, on behalf of County Executive Olszewski and the citizens of Baltimore County, let me thank the members of the commission for volunteering your time and your expertise to carry out this work, and thank again the members of the public who shared with us tonight. Can I get a motion to adjourn?
So moved.
I move.
Okay, and a second?
Second.
Second. Oh. All right.
I thought I was seconding Tom. I thought Somebody beat me to the motion, so it was just a second.
Okay, so we have a motion and a second, and so with that, the meeting is adjourned, and we'll let you know when that next meeting will be. Take care, everyone. Have a good night.
Thank you.